Thank you so much, Tyrell. And this is a special edition of Let's Talk Legal, brought to you with the compliments of Neumann van Rooyen attorneys. And today I do have Dries Knoetze, and he's going to be elaborating a bit more on a case that he dealt with involving Rand Mutual Assurance. Dries, thank you once again for joining us in studio.
Hi, Jessica. Thank you for having me once again. Yes, I was recently involved in a matter against Rand Mutual Insurance, and it's actually a very close matter of mine. The appellant was my father, and he was actually the one who took on Rand Mutual Assurance.
Now, Dries, I must say, I was, just reading and doing some background with the information that you supplied me with, and it's actually very, very interesting, and you have quite a lot of, important points to bring across. So, Dries, I heard that there was, as you said recently, a judgment relating to a gold miner from the goldfields in terms of which you took on Rand Mutual Assurance, and I understand, of course, you were part of this case. So, can you give us a bit more background as to how this matter actually came about?
All right. The gold miner, as I said, is my father. He was employed at Harmony Gold Mine in Unrich for about 39 years and worked in various areas of the mine. Mm-hmm. He was a fitter and turner initially, and then later on became a mechanical foreman. Now, as a result of his job, he was employed underground and above on surface, and he worked with heavy machinery, had to repair them. And later on, a few years before his retirement, he then completely lost his hearing, and as a result thereof, he was then dismissed by the mine because of occupational requirements. He could not hear and receive instructions, which caused, of course, a safety hazard underground. Mm-hmm. Now, initially I assisted him to lodge an appeal against the decision of the mine doctor, who indicated that he suffers from noise-induced hearing loss, which we then appealed in terms of the Mine Safety Act to the Inspector of Mines, and the Inspector of Mines came back and said, well, he concurs with the decision of the medical doctor. He also concedes that it's noise-induced hearing loss, and as such, and because of the safety implications thereof, he then proposed that my dad worked in an area with lesser noise. Ultimately, the mine could not accommodate my father, and then he was dismissed. Now, because of the fact that Rand Mutual Assurance is licensed in terms of the COIDA Act, that's the Occupational Compensation for Occupational Injuries and Diseases Act, they were supposed to then compensate any employee who then received a disability or had a disability as a result of the working under mine. And we then submitted a claim to Rand Mutual Assurance. Now, with our claim, we submitted 2 supporting documents and specialist report by, amongst others, a general practitioner, 2 ENT specialist doctors, who confirmed, all of them confirmed that my dad then suffered from noise-induced hearing loss.
And so you've mentioned now that you went to go seek advice from an ENT specialist doctor. What is that actually?
Now, ENT specialist doctor, that's a nose, ear, and throat specialist. They specialize in ears and those types of things. And then they confirm the diagnostics of both the Inspector of Mines and the mine doctor that my dad suffers from hearing loss. So we, with all good merit, then submitted a claim to the Rand Mutual Assurance for then the compensation of the disability.
Now, I assume that the claim was then repudiated.
Yes, the claim was repudiated, despite the specialist report, as I said, and despite the fact that we had uncontested evidence from a chief safety officer who was also in the employment of the mine, confirming that, well, my dad worked in a noisy area most of his career, and the RMA then rejected the claim. We objected to the repudiation, and I must say, and I pause to mention that at the stage of the rejection, no reason was provided from the RMA explicitly saying us the reasons why they reject the claim. The only type of reason that they gave us, they told us that, well, we conceded this noise-induced hearing loss, but it's atypical now. Atypical is not, it doesn't look like the normal hearing loss, and the reason for that was because of the rapid loss of hearing. They were under the impression that because of that, they are not going to accept the claim.
Now then, what happened next?
All right, now in terms of the Act, then when your claim is repudiated, then you have to schedule a tribunal hearing. Now, the tribunal is set up by Rand Mutual Assurance, and they also pay and appoint the members of that tribunal, which is interesting, to put it bluntly. Now, these members include normally a legal practitioner, an advocate or an attorney somewhere, a general medical practitioner, a normal doctor, and also an employer representative will then chair this discipline or this tribunal hearing. Now, at that particular stage in time of the matter, I then elected to appoint another attorney because of my close relativity to my father, and to keep it objective. I luckily got hold of also a Goldfields born and bred lawyer who's now practicing in Johannesburg, George Kahn, who is at Richard Spoor Attorneys, and he then assisted us, me and my father, with the matter at the hearing as well as the appeal to the High Court in Gauteng later on.
Now, Dries, can you tell us a bit more about what happened at this hearing?
Okay, at this hearing it was done via MS Teams virtually. And at this hearing, we both then tendered evidence of this ENT doctors. They testified, the one testified for about 3 days and the other one testified for a day, as well as this chief safety officer who confirmed then that my father worked in a noisy area for most of his career, and also that he then suffered from noise-induced hearing loss. What's strange was that the Rand Mutual Assurance did not tender any evidence at this hearing. They had one doctor there at the end of their case just basically saying, well, they deny that. Oh. And that was it. So at the outcome of the tribunal hearing, they then ruled that, well, my father was not entitled and that he could not prove a direct link between his hearing loss and his employment, which is very important, and I will deal with that later on. But we then appealed the ruling to the Gauteng High Court, and 2 judges heard the matter. And they, in their judgment, indicated that sufficient evidence was put forth by Mr. Knoetze and seemingly ignored by the tribunal. They also said the crux of the matter was that at the tribunal hearing, the tribunal misinterpreted the provisions of Section 66 and 65 of the Act, and incorrectly placed the onus on my father to prove his case on a balance of probabilities.
Now, what does that all actually mean?
All right. If I can dumb it down a bit, Section 66 creates a presumption now in favor of the employee. Now, that presumption basically means that the employee have to prove that, one, he was employed in a certain area, and secondly, that a disability occurred. Now, if I can give you an example, and take the example here, is you're sitting with an employee who worked in the mine for 39 years. He is a mechanical foreman and a fitter and turner, which means that he works on very large, very noisy machinery. It's common cause that underneath the ground in a mining environment, it's noisy. So what this entails is that, one, you must prove that you have a disability, and secondly, that you were in a noisy environment. Now, this was proven, and for that reason, the presumption is written in the Act. This presumption is written in the Act to alleviate the imbalance of power against the large employer and the small employee. This presumption will then, if the employee can trigger that presumption, will cause Rand Mutual to go and investigate and appoint doctors to see whether or not there's a direct link between the disability and the environment. It's not for the employee to prove. Now, because of that, the judges also in their judgment indicated that this presumption is written in the Act to alleviate that imbalance because of the fact that the employee most likely does not have the knowledge nor the funds to get hold of these expert doctors and so forth to assist. And because of that, the judges then upheld the appeal in order that my father was entitled to his compensation.
Now, Dries, I can only just imagine that this hearing has a huge impact going forward.
Yes, not only on the specific employee at this stage, but also in the cases of employees whose cases were previously assessed by Rand Mutual. it will be my view that those cases had to be drawn, and one have to investigate whether or not the Rand Mutual once again made the correct misrepresentation about the act, whether or not the onus was once again put on the employee, or whether Rand Mutual accepted the onus and then put forth any evidence to prove that there is no direct link between the disability and the environment. And I believe that most employees have little to no funds to approach an attorney or doctor for assistance. In this instance, luckily, George of Richard Spoor Attorneys was there, and myself to assist my father. But it's very important that should you be of the view that your case was unfairly dealt with by Rand Mutual, which is not a stab in the dark, that you approach an attorney with the necessary expertise to assist you and have a look at your case, to make sure that the correct interpretation was followed by Rand Mutual and especially that tribunal.
Absolutely. Now, I mean, Dries, going through all of this, do you have any advice for an employee who suffers from a disability and does struggle with Rand Mutual Assurance?
Well, my advice would be to contact an attorney as soon as possible. If you try to take on the tribunal and Rand Mutual as a whole, you will face challenges. You will be required to have insight not only into the law, but into the interpretation of the law, as well as a certain medical background to assist you to see whether or not you actually have merits in taking on Rand Mutual.
Absolutely. Dries, well done. I think you did an amazing job on this case, and thank you so much for shedding some light on something so important.
Thank you, Jessica. I appreciate it.